Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Dr. Kavita Solanki, Professor of Law at University School of Law and Legal Studies, Guru Govind Singh Indraprastha University, Delhi, Dwarka. Today we will talk about Labour and Industrial Law 1, where we would be talking about lecture number 9, Equal Remuneration Act 1976. Objective of Equal Remuneration Act 1976 to provide equal remuneration to both men and women workers for same work or work of a similar nature. This act has been created with the object to remove the discrimination between the men and women and to provide them equal remuneration for the same work or a work of a similar nature. To avoid the discrimination on the basis of gender in the matter of employment or recruitment unless mentioned in the act like Factory Act. Because when we talk about Factory Act, into Factory Act, special provisions has been made for the female. Say because female they have been, they should be provided with a separate washroom and the toilet with the handles, or the crutch facilities has to be provided to the female where the number of the female are 30. The crutch has to be provided, or special provisions for the safety provisions has been made, like the employer cannot tell it to the woman to lift a particular weight which has been prescribed. They can lift that particular weight, not beyond that. So, or otherwise the woman cannot be allowed to work into the factory where the risk or the hazardous machines are involved. ILO Convention number 100 and Indian law. The Equal Remuneration Convention number 100 was formally adopted in 1951 and entered into the force in May 1953. This convention number, Equal Remuneration Convention number 100, had been adopted in India into the year 1951. The convention focuses on gender discrimination in employment and outlines principle of equal remuneration for work of equal value, independent of whether it is performed by men or women, because this convention focuses basically to remove the gender discrimination, and that is clearly mentioned that if the man and the woman they are doing the similar kind of the work, equal remuneration has to be provided to both of them. To achieve the equal pay, parties to the convention are required to implement domestic laws and the regulations on wage determination and the support collective agreements between the workers and the employers organizations. The Equal Remuneration Act 1976 provides for the equal remuneration to both men and women in India. So, because of this, because India is a party to it, India is already signatory to the ILO Convention number 100, and we have adopted this convention. On that basis, this convention has been adopted in municipal law and it is applicable here in India. So, it has been clearly mentioned that there will not be any discrimination between the men and the women for the employment. Convention number 100, Equal Pay for Equal Work Convention 1951, ratified by India on 25th September 1958. Convention number 111, Discrimination, Employment and Occupation Convention 1958, again India has ratified this on 3rd June 1960. If we talk about other countries, in USA, also the Equal Pay Act has been passed, which came into force in June 1963, which helped in erasing wage discrepancies based on sex. In USA also, this convention has been adopted in 1963 and they have removed the discrepancy between the men and the women in terms of the wage. In England in 1970, the Equal Pay Act was passed, giving right to the individual pay for the similar work, women to claim equal pay for the similar work. In 1970, this convention had been adopted and for the similar kind of the work, the equal pay has been given to the women. Provisions under our constitution, Article 16 clause 2, it is a fundamental right. It says that no citizen shall on ground of any gender be made ineligible for or discriminated in respect of any office or employment under the state. It means this is the fundamental right of any citizen of India, that is, they cannot be ineligible on the basis of the employment. So, this is the responsibility of the state. They cannot make the discrimination on that basis, especially when we are talking about in cases of the employment. Directive principles of state policy, Article 39A says that men and women must have an equal right and they should be provided the equal facilities. Article 39D says that there must be equal pay for equal work. So, that this is the purpose, that is all the policies they have to be drafted in such a way that is both the male and the female, they should be getting the equal right. First applied into the establishment being covered under the Plantation Labour Act on 15th of October 1975 and thereafter from January 1976 onwards to all the other authorities. So, this convention, that is this has been adopted. This act is firstly adopted under the Plantation Labour Act and in the year 1975 and thereafter from January 96 onwards, that is applicable to the other local authorities. When we are talking about the Equal Remuneration Act in Randhir Singh versus Union of India and others in 1982, Supreme Court has held that it is true that the principle of equal pay for equal work is not expressly declared by our constitution to be the fundamental right, but it is certainly a constitutional goal. So, Article 39 clause D of the constitution proclaims equal pay for equal work for both men and women as a directive principle of the state policy. It is clearly mentioned that equal pay for equal work is not the fundamental right, but this right has been given under the directive principle of the state policy, and the purpose is the equal pay for equal work has to be provided to both the men and the women. Equal pay for equal work for both men and women means equal pay for equal work for everyone and as between the sexes. Directive principle, as has been pointed out in some of the judgments of the court, as we discussed, the cases Randhir Singh versus Union of India and many more cases have been read into the fundamental rights as a matter of interpretation. Article 14 of the Constitution enjoins the state not to deny any person equality before the law or the equal protection of the laws, and Article 16 declares that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. These equality clauses of the Constitution must mean something to everyone. To the vast majority of the people, the equality clause of the Constitution would mean nothing if they are unconcerned with the work they do and the pay they get. To them, the equality clauses will have some substance if equal work means equal pay. In Union of India versus Indian Navy Civilian Design Officer, into this case, in 2023, Supreme Court has observed that this doctrine, equal pay for equal work, is not an abstract doctrine and is capable of being enforced in a court of law. The equal pay must be for equal work of equal value. The equation of post and the determination of pay scales is the primary function of the executive, not of the judiciary. The courts therefore should not enter upon the task of the job evaluation, which is generally left to the expert bodies like the pay commissions. When we talk about Equal Remuneration Act 1976, it contains 18 sections and 3 chapters. First chapter deals with the applicability, Second, and into which we are talking about, we would be dealing with some important definitions, and the third is talking about the miscellaneous. Chapter 2 deals with the payment of remuneration at equal rates to men and the women worker and other matters. This act is, Equal Remuneration Act is applicable all over India and came into force on 1976. It shall came into force on 8th of March 1976. When we talk about the important definition of this act, we are having some important definitions which are very important to know. First is appropriate government. Who would be the appropriate government for the under this act? Appropriate government means in relation to any employment carried on by or under the authority of the central government or a railway administration, or in relation to the banking company, a mine, oil field or major port, or any corporation established by or under the central act, that is the central government. So all these departments, they would be coming under the central government, because the central government is the appropriate government here. And so all these departments like banking company or mine, oil field or major ports or any corporation which has been set up or under the central act would be coming under the central government. So for this, appropriate government is the central government, and in relation to the other employment, the state government is the appropriate government. Commencement of this act means in relation to an establishment or employment, the date on which this act comes into force in respect of that establishment or employment. Employer here meaning the meaning which has been given under the Payment of Gratuity Act 1972. The same meaning has been given here under this act is of the employer. Men and women means male and the female human beings respectively of any age. So when we are talking about men and women means male and the female irrespective of any age. It can be 20, it can be 30, it can be 50, so it can be of any age. Notification means notification published in the official gazette. Prescribed means prescribed by the rules made under this act. Remuneration means the basic wage or the salary and any additional emoluments whatsoever payable either in cash or in kind to a person employed in respect of the employment or work done in such employment if the terms of the contract of the employment express or implied were fulfilled. Remuneration here means again we are talking about, that is here we are including it can be the basic wage or it can be the salary or any additional emoluments has been given by the employer. It can be either in a cash or in kind, because here we are permitting, that is in kinds we are covering here under this act to a person employed in respect of the employment or work done in such a employment. And but if the terms of the contract of the employment, they have to be very clear, either it has to be expressed or implied, they have to be fulfilled. The most important definition of the act is same work or work of a similar nature, means work in respect of which the skill, efforts and the responsibility required are the same when performed under the similar working condition by man or a woman, and the differences, if any, between the skill, efforts and the responsibility required of a man and those required by or to a woman are not of a practical importance in relation to the terms and the condition of the employment. Similar work or a work of a similar nature means, see, we normally check the three things, that is skill, efforts and the responsibility. They are very important. If a man is exercising the skills, efforts and the responsibility, and the same skills has been exercised by the female, same responsibility, same effort has been done by the woman, that would be amount to the same work of a or a work of a similar nature. Sometime if there is no practical difference into the the output of it, the same effort had been made by both the sides, but practically there is no difference, there is no no one is both the person they have given the equal efforts, then we would be saying this is a case of the same work and the same that is a same work or work of a similar nature. Worker means a worker in any establishment or employment in respect of which this act has come into force. Words and the expression used into this act are not defined, but defined into the Industrial Dispute Act 1947 and having the same meaning respectively. Section 3 is talking about act to have an overriding effect. The provision of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law or in terms of any award, agreement or contract of service, whether made before or after the commencement of this act, or in any instrument having effect under any law for the time being in force. So, this act is having the overriding effect. If we are talking about one more important case, that is Miss Mackinnon Mackenzie and Company Limited versus Andre de Costa and another. Into this case, it was urged on behalf of the management that the difference between the remuneration of the male stenographers and the confidential lady stenographers was on account of the settlement arrived at after proper negotiation. It was held that in view of section 3 of the act, the provision of the act shall have effect notwithstanding anything inconsistent therewith contained in any other law or in terms of any award, agreement or contract of service, whether made before or after the commencement of the act or in any instrument having effect under any law for the time being in force. Therefore, the settlement must yield to the provision of this act. If the things has been very clearly decided, that is the man would be doing, the male stenographer, they would be getting the equal pay. And on the other hand, because into this act we are not saying that there is any kind of the partiality has been made. This is not against or not favoring anybody. Here we are protecting both the male and the female, both the male and the female, they should not be discriminated for the equal pay for the equal work. So, this is the legislation which provides the protection to both the parties. Chapter 2 is talking about payment of remuneration at equal rates to men and women worker and the other matters. In section 4, it is a duty of the employer to pay equal remuneration to men and the woman worker for the same work or the work of a similar nature. No employer shall pay to any worker employed by him in any establishment or employment remuneration, that is in terms of the wage or the salary, whether payable in cash or in kind, at a rates less favorable than those at which the remuneration is paid by him to the workers of the opposite sex in such establishment or employment for performing the same work or work of a similar nature. So, this is the duty of the employer is to make the equal remuneration to both the male workers and to the female workers if they are doing the equal work or work of a similar nature. The person employer cannot make any discrimination on that basis. No employer shall for the purpose of complying with the provision of subsection 1 reduce the rate of remuneration of any worker where in an establishment or the employment the rates of remuneration payable before the commencement of this act for the man and the woman worker for the same work or work of a similar nature are different only on the ground of the sex, then the higher in case where sometimes there are the two rates, or as the case may be the highest in case of where there are the two rates, of such rate shall be the rate at which remuneration shall be payable on and from the such commencement to such man and the woman worker. If into this, because this is the duty of the employer is to make the payment to the male workers and to the female workers equal pay, that is, but if the employer wants to reduce the wages because he don't want to give the equal wages to the opposite sex, and so if the employer is going for this kind of the practices, this is not permissible. Provided that nothing in this subsection shall deem to be to entitle a worker to the revision of the rate of the remuneration payable to him or to her with the reference to the service rendered by him on her before the commencement of this act. When we are talking about Equal Remuneration Act, so this act has been created for the protection of the for both the male and the female workers, if they are doing the work into the similar kind of the employment and doing the similar kind of the work. It means both the parties, they are giving the equal, they are very much responsible, and making the 100% efforts and using the skills to complete this kind of the task. So when we talk about, but this is limited up to the male and the female workers. But when we talk about it, because now the code on wages they came into the picture, and Equal Remuneration Act has been amalgamated into that code on wages. This is one of the legislation which has been subsumed there. So when we talk about it, under section 3 of the code on wages, it has been clearly mentioned there, that is prohibition of discrimination on ground of gender. So into this code on wages, there shall be no discrimination in an establishment or in any unit thereof among the employees on the ground of gender in matters related to the wages by the same employer in respect of the same work or the work of a similar nature done by an employee, for the purpose of complying with the provision of subsection 1, reduce the rate of the wages of any employee and make any discrimination on the ground of the sex while recruiting any employee for the same work or work of a similar nature, and in the condition of the employment except where the employment of the woman in such work is prohibited or restricted by or under any law for the time being in force. So it is also very clear that the protection here, first is they are talking about the prohibition of discrimination on the ground of the gender, because nowadays we are talking about the third gender also. So the protection has to be given it to that third gender also, because otherwise if we would be making the discrimination on the basis of the gender at the time of the employment, this is not permissible, because we are putting the third gender also in the, so ambit of this section is broad now. Section 5 is talking about no discrimination to be made while recruiting man and women workers. On and from the commencement of this act, no employer shall, while making recruitment for the same work or work of a similar nature or in any condition of service subsequent to the recruitment, such as the promotions, training or transfer, make any discrimination against women except where the employment of the woman in such work is prohibited or restricted by under any law for the time being in force. So no discrimination can be made by the employer at the time of the recruitment, for the training, if they are having both the workers, both the male and the female. So at the time of the recruitment there cannot be any kind of the discrimination, and at the time of the training or the other things, the employer cannot make the discrimination except which has been prohibited or restricted by under any other law for the time being in force. So sometime what happen, we are having the provisions which are given under the Mines Act. Into the mines the female workers, they are not allowed, but because this is only the intention is to give the protection to the females. So otherwise when we talk about it, where this kind of the proviso is there or the protection has been given, only that is permitted. Otherwise that is a general rule is there cannot be any discrimination, provided that the provision of this section shall not affect any priority or reservation for the scheduled caste or the scheduled tribes, ex-serviceman, retrenched employees of any other class or categories of the persons in the matter of recruitment to the post in any establishment or employment. So only the favor can be given to these persons. Say for example the scheduled caste, they of course this kind of the provision is there for to make the reservation for them, either it is a case of scheduled caste or the tribes, scheduled tribes or ex-servicemen, or if any of the person has been that is a retrenched employee from the industry, so they must have to be given the favor. So this is not the discrimination. In section 6, we are having the advisory committees. So, for the purpose of providing increasing employment opportunities for the women, the appropriate government shall constitute one or more advisory committees to advise it with regard to the extent to which women may be employed, and in such establishment or employments as the central government may by notification specify in this behalf. So, this is because into any of the this is the duty of the appropriate government. They would be constituting the advisory committee, and there can be one or the more advisory committee can be there who they would be giving the advice. They would be giving the advice to what extent female can be employed in a particular establishment or any of the employment. So for this the central government they can notify accordingly. Every advisory committee shall consist of not less than 10 persons to be the nominated by the appropriate government, of which one half shall be the women. Because earlier the advisory body members, they were the 6, now this number has been increased now. So, now the limit has been 10 members would be there into the advisory body, and out of this the 50% would be the female. In rendering its advice, the advisory committee shall have regard to the number of the women employed in the concerned establishments or employment, the nature of work, hour of work, suitability of the women for employment as the case may be, the need for providing increasing employment opportunities for women including part-time employment, and such other relevant factors as the committee may think fit. So, the role of this advisory committee is for the regard of they are talking about the employment, so they can give their advices, that is for a particular employment or for the establishment, depends upon the nature of the work. So, how many work hours they would be doing the work, suitability for whether it is suitable for the woman for this this kind of the employment is suitable for the woman as the case may be, or they can whether how the employment opportunity, how the employment opportunity can be increased for the for the women, and how the this part timers can be employed, and any other kind of the important factors for which they think suitable, they can give the advice to the government. The advisory committee shall regulate its own procedure. The appropriate government may, after considering the advice tendered to which has been given by the advisory committee, and after giving to the persons concerned into the establishment or the employment an opportunity of make the representations, issue such a direction in respect of the employment of the women workers as the appropriate government may think fit. So, the advice of the this advisory committee is very important. So, they would be deciding the procedure and they would be giving the equal opportunity. So, the affected party, they can make their representations, and accordingly the appropriate government, they would be taking the note of everything, and accordingly the direction would be given in respect of the employment of the women workers, and with the government may think fit, they can take the suggestions into the considerations. Section 7 is talking about power of the appropriate government to appoint authorities for hearing and the deciding the claims and the complaints. So, here in section 7, power has been given to the appropriate government. They can appoint the authorities who would be hearing and deciding the claims, and they would be addressing the complaints under this act. So, the appropriate government may by notification appoint such officers not below the rank of a labour officer as it thinks fit to be the authority for the purpose of hearing and deciding complaints with regard to the contravention of any of the provisions of this act. If any contravention has been made, if the provision has not been if any of the contradictory thing has been done under this act, the complaint can be given. So, claims arising out of the non-payment of the wages at equal rates to the men and the women workers for the same work, or work of a similar nature. So the claims can be, if there is a complaint that is like equal payment has not been given to the male and the female workers, they were doing the similar kind of the work that was a similar in nature. So this kind of the complaint can be filed here and may by the same or the subsequent notification define the local limits within which such authority shall exercise its jurisdiction. So here it is not necessary, because here the appropriate government, they can appoint the authorities and they can decide the jurisdiction, who would be taking the matter and which area would be coming under the authority. So the jurisdiction can be decided under this act. So just to not to encroach upon the area of the other jurisdiction. Every complaint or claim referred to in subsection 1 shall be made in such a manner as may be prescribed. If any question arises as to whether two or more works are of the same nature or of a similar nature, it shall be decided by the authority appointed under subsection 1. So if there is a question is these are the these kind of the employment, and they are saying that two employment, they are not of a similar nature or of a similar nature. So this is the job of the executive. So here the matter would be deciding by the authority which has been appointed under this act. Where a complaint or claim is made to the authority appointed under subsection 1, it may, after giving the applicant and the employer an opportunity of being heard, and after such inquiry as it may consider necessary, direct. So principle of equal opportunity has to be applicable, has to apply, because they must have to give the chance to each other, that is a opportunity of being heard. And so after that the inquiry has to be made by the authority, and later on if they think consider necessary, they can give the directions accordingly. So in case of a claim arising out of the non-payment of the wages at equal rates to men and the women workers for the same work or work of a similar nature, that payment be made to the worker of the account by which the wages payable to him exceed the amount actually paid. So if the wages has been paid earlier, the wages which were paid, they were the less. So the appropriate government, this authority, they can give the direction to make the exceed the amount of the wages which has been paid. So they can give the direction to exceed the amount. And in case of the complaint, that adequate steps has to be taken by the employer so as to ensure that there is no contravention of any of the provision of this act. So this kind of the direction can be given for the employer, that is if they have received the complaint that is the employer is not bothered about the provisions of this act, they are making the contravention of the provision which has been given under this act is, so the direction can be given, that is the adequate steps has to be taken by the employer, and make it ensure that there will not be any contravention of any of the provisions which has been given under this act. So every authority appointed under subsection 1 shall have all the powers of a civil code under the Code of the Civil Procedure 1908 for the purpose of taking the evidence and for enforcing the attendance of the witnesses and compelling the production of documents, and every such authority shall deem to be the civil court for all the purposes of section 195, and that is for the Code of the Criminal Procedure. So they are having the authority would be having the power of the civil court, and they can whatever is relevant and required here for the better functioning for this. So they can, if they want to call any of the witness, they can call the witness. If they need any kind of the documents, they can ask for the document. So that is the power has been given, and so they can do in that way. Any employer or the worker aggrieved by any order made by the authority appointed under subsection 1 on a complaint or claim may within 30 days from the date of the order prefer an appeal to such an authority as the appropriate government may by notification specify in this behalf, and that authority may after hearing an appeal confirm, modify and reverse the order appealed against, and no further appeal shall lie against the order made by such a authority. So, if either the employer or the worker, they are not okay with the order which has been given by the authorities, they are having the right of the appeal. So, within a 30 days they can go against the order of that particular authority. So, they are having the system for the appeal, they can go for the appeal within the next 30 days. The authority referred to in subsection 6 may, if it is satisfied that appellant was prevented by sufficient cause from preferring the appeal within the period specified here, allow the appeal to be preferred within a further period of 30 days, but not thereafter. So, sometime the person is not allowed to go for the appeal, but if they feel so like there was a genuine reason, then they can give the chance and the person can go for the appeal against the decision of the authority, and they allow the appeal, but the time period is within a 30 days, but not later on. The provision of subsection 1 of section 33C of the Industrial Dispute Act 1947 shall apply for the recovery of the monies due from the employer arising out of the decision of an authority appointed under this section. So, Industrial Dispute Act will come into the picture, and if they want to recover the money, then in that case, that is all the proceedings would be proceedings can be made under the Industrial Dispute Act 1947. Duty of the employer to maintain the register. In section 8, it is the duty of the employer to maintain the register, because this is very, very important. So, if they want to be maintaining the register, for this the employer can be held responsible. So, on and from the commencement of this act, every employer shall maintain such registers and other documents in relation to the workers employed by him and may be prescribed. So, this is duty of the employer is when this act came into the implementation, from that onwards they must have to maintain the register, they must have to, and this kind of the register has to be maintained into the prescribed forum. Section 9 is talking about inspectors. So, appropriate government may by notification appoint such person as they think fit to be the inspector for the purpose of making the investigation as to whether the provision of this act are being compiled by the employer or not. In order to ascertain the offence, the appropriate government is given a task to appoint the inspector, and he will be responsible for carrying out the investigations. So, without the inspector is, because it is very, very necessary that the inspector has to be there, because the role of the inspector is the inspector would be making the investigation, and I mean just for the better functioning, or that is just to check everything, because the appropriate government they appoint the inspector and who would be responsible for carrying out all these investigations. Accordingly, in section 8 clause 2 of the act, the inspector must be a public servant. Section 21 of the Indian Penal Code provides 12 broad categories of a public servant, where the post of the inspector must lie, otherwise his or her appointment will consider to be the unauthorized. So, when we are talking about the inspector is the public servant. So, when we are talking about public servant has been, that is given under the Indian Penal Code, so like that person should be the inspector, and accordingly he would be making the this person can be appointed by the government, and he would be making the investigations and he would be preparing the report. So, all the responsibility will lie upon the inspector. Into this act we are having the penalties. So, under section 10, which is very, very important, that is for the minor offences or for the major offences, the system of the penalty is given. So, if a person is doing that act, because when we are talking about the minor offences, for this the penalty has been fixed, that is in that case punishment would be the simple imprisonment of 1 month or a fine up to the 10,000 or both. So, if it is a case of the minor offence, that is punishment would be the 1 month, or that is the fine can be imposed up to the 10,000 in that case, and sometime the both. So if we are talking about the minor offences is a failure to maintain any register or muster roll, failure to produce any register when asked for, or refusal to give the evidences, refusal to give the required information to the inspector. So if the inspector is asking for the register, but employer has not maintained any register and they are not having the muster rolls. So when we are talking about, so it is not possible to understand how many the workers they are doing the work into that particular establishments. So this is just to this is the duty of the employer to maintain the record. If the record is not ready, then the employer can be held liable for this. Failure to produce any register when asked for, because that is the register, he has not maintained that record, that's why the person is he has not made any complied with the provisions which has been mentioned under this act. And refusal to give the evidences, if the employer employer refuse to give any kind of the evidences, if they are asking any kind of the sportive evidence, if the person is not providing this making the denial of it, then the employer can be held accountable for it. Refusal to give required information to the inspector, if the inspector wants to know something, the status and everything which is related with this establishment, but if the intentionally, if the employer refuse to give such a kind of the information, then in that case the employer can be held responsible. So these categories of the offences, they come under the minor offences under this act, and for this 1 month imprisonment can be 1 month imprisonment can be given to the person, and 10,000 rupees can be imposed, and sometime both can be given it to the employer. When we are talking about the major offences under this act is making any recruitment against the provision of this act. So because making any recruitment under the provision of this act is because this act would be applicable for the same work, and the equal opportunity would be given to the man and the woman. But if the person is making any kind of the recruitment which is against the provision of this act is, then in that case it is considered to be the major offence. Not giving equal pay for equal work. So this is the strong denial, or this is the contravention of this act is, because the purpose of this act would be defeated. So if the person is employer is not ready, has not given any equal pay for the equal work, then it is a serious offence, and for this the person can be imprisonment can be given to the person that is from 3 months to 1 year, and that is next is discriminating, contravening any provision of this act. So if the person is employer is making the any discriminations so toward any of this sex, so and making the contravention, so the person can be held accountable. Failure to carry out the instructions being provided by the appropriate government with regard to this act. If the appropriate government they have given the directions, this kind of the instructions has to be followed. But if the employer is not following those instructions which has been given by the appropriate government, and the appropriate government is the absolute government, absolute authority who has to see the things like righteous things. So if the person is not obeying the instructions which has been given by the appropriate government is, he can be held liable, and so these kind of the offences comes under the category of the major offences. For these kind of the offences, punishment can be given it to the employer, and so 3 months to 1 year imprisonment can be made, and he can be the fine can be imposed, that is from 10,000 to 20,000 in that case, and sometime the both can be given. So sometime the offences which has been done by the companies, where an offence under this act has been committed by the company, every person who at the time of the offence was committed was in charge of, and he was responsible to the company for the conduct of the business of the company as well as the company, shall deem to be the guilty of the offence and shall be liable and to be proceeded against, and punished accordingly, provided that nothing contained in this subsection shall render any such person liable to any punishment if he proves that the offence was committed without his knowledge, or that he had exercised all due diligence to prevent the commission of such an offence. If the person is saying, because the person is saying he had no information whether this kind of the discrimination has been done into the company, then in that case he has to give the, that is the onus of proofs lies upon him only. He has to prove it. He had not been negligent. He has taken the due diligence in that case. So this is the responsibility of the who is the in charge of the company in that case. So they must have to prove it. Notwithstanding anything contained in subsection 1, where any offence under this act has been committed by a company and it is proved that offence has been committed with the consent and the convenience or attributable to or any neglect or the part of any director, manager, secretary or other officer of the company, such director, manager, secretary or the other official shall deem to be the guilty of that offence and shall be liable and to be proceeded against them and punished accordingly. So, if because into the last point we were talking about, there is no fault of the that is a manager and the responsible person, but here if these persons they are involved, then in that case they could be responsible and they would be held responsible, and so they can be penalized. So if they are involved into this kind of things, part of the discrimination and not making the compliance of this act. So when we are talking about company means any body corporate, and it includes a firm or the other association of the individuals. And when we are talking about the director, in relation to the firm means a partner into the firm. In section 12, cognizance and the trial of the offences. So no court inferior to that of the metropolitan magistrate or judicial magistrate of the first class shall try any offence punishable under this act. So because here if we are talking about the cognizance and the trial of the offences, only the metropolitan magistrate or a judicial magistrate or the first class will try the offences here, and no court shall take cognizance of any offence punishable under this act except upon its own knowledge or upon a complaint made by the appropriate government or any officer authorized by it in this behalf. So, and a complaint made by a person aggrieved by the offence or by or any recognized welfare institution or the organization. So, when we are talking about because these kind of the things comes into the knowledge of the that is of the appropriate government, that is when they receive the complaints or any of the officer which has been authorized for this purpose only. So if they are receiving the complaints from any either from the agreed person that is the offence has been done, or the complaint can be received, the complaint can be given by the recognized welfare institutions or any other organizations. So they can start with this kind of the trials. So for the purpose of this section, recognized welfare institutions or the organization means a social welfare organizations or institutions recognized in this behalf by the central or the state government. Power to make the rules. The central government may by notification make rules for carrying out the provision of this act, in particular and without prejudice to the generality of the foregoing power. Such rules may provide for all or any of the following matters: the manner in which the complaint or the claim referred to in subsection 1 of section shall be made, because when we are talking about the here, that is the central government would be making the rules relating to it, how the complaint can be filed, what is the procedure. So this is the central government would be deciding how the things can be done accordingly. So the manner in which the complaint or the complaint to be given under this section 7, registers and the other documents which an employer is required under section 8 to maintain in relation to the workers employed by him, because the appropriate government can make the rules relating to the register of a, that is the duty of the employer, they must have to maintain the registers. So, into which what kind of entry has to be made, everything has to be decided by the appropriate government, and they would be deciding it. And any other matter which is required to be made or may be prescribed. So, appropriate government can tell that what kind of the matter, if any other matter which is relevant, that can be added by the appropriate government. Every rule made by the central government under this act shall be laid as soon as after it is made before each house of the parliament while it is in session, or the total period of the 30 days which may be comprised in one session or in two or the more successive sessions. So, if any of this central government, already we have seen, that is, if any of the central government they want to lay down any of the they want to make that they want to lay down something, then it can be made before each house of the parliament, because the first is they would be moving it before the Lok Sabha, after that the Rajya Sabha, and so accordingly before the standing committee. So, this is the process, and so this kind of the things can be done within that is for a period of the 30 days, and that is into the particular session only, because when the sessions are going on, they can move this kind of the exercise at that time only. If before the expiry of the session, immediately following the session or the successive session aforesaid, both the houses agree in making any kind of the modifications into the rule, this thing, they can go that. So, this kind of the rules can be made when the session is in process. So, or both the houses agree that the rule must be made, or the rule shall thereafter have effect only in such a modified form and be of no effect as the case may be. So, however, that any such modifications or the annulment shall be without prejudice to the validity of the anything previously done under this rule, and so they would be doing in that way. Power to make a declaration. So, the appropriate government is on a consideration of all the circumstances of the case satisfied that the differences in regard to the remuneration or a particular species of the remuneration, or man or a woman worker in any establishment or employment is based on a factor other than the sex, it may by notification make a declaration that to that effect that any act of the employer attributable to such a difference shall not deem to be in contravention of any kind of the provision under this act. So, if they feel so, that is there is a discrimination has been made, but that is not based upon the sex. So, they can that would be, it will not considered to be that is under the purview of this act. So, this kind of the declaration has to be made by the appropriate government, like there can be other factor is there. So, they would be making the notification and they would be making the declaration that is this kind of the act of the employer, there is a this kind of the this act is not coming under the purview of the this Equal Remuneration Act. Because the Equal Remuneration Act deals with that is, if there is there is a discrimination on the basis of the sex only, and they are not giving the equal remuneration to the opposite sex, and they are not giving the at the time of the appointment or for the remuneration, they are not giving the equal opportunity to the other party. So, if that case does not fit here, so appropriate government would be making the declaration this case is not fit here. Power to remove the difficulties. So, if any difficulty arises in giving effect to the provision of this act, the central government may by notification make an order not inconsistent with the provision of this act which appears to it is necessary for the purpose of removing the difficulty, and provided that every such order shall as soon as may be, after it is made, be laid before such each house of the parliament. So, when we are because we are talking about the implementation of this act, but if any kind of the difficulty arises, that is to giving the effect of the provision of this act here. So, the central government, they will notify it, and they would be putting the matter before the before the parliament. This is a difficulty, so they can they can make the amendment, and we are having the system, because if we want to come up with a very good kind of the legislations, so the chances is the things cannot be ready once. So, we are having the system, so they can be revised, so they can revise it later. So, this is the power of the government, and the understanding is they want to remove this kind of the difficulty, so for the better implementation of this act. So, this is regarding your Equal Remuneration Act 1976, and this is from my side. Thank you so much.
Hello, I am Shikha Dikshit. I teach psychology and I work with the Department of Humanities and Social Sciences at IIT Kanpur. Today I will talk about what is causal attribution, or how do people understand causes of behavior. Causal attribution is one of the major topics in social cognition in psychology, and this refers to the fact that people attribute causes to their own behavior as well as to behaviors of others. So, understanding the antecedent conditions of behaviors and events is one of the major topics in social cognition. Causal attribution is about finding explanations, and these explanations serve a functional purpose, since they are useful in the purpose of planning of behavior and regulation of responses. As far as attribution of causes is concerned, generally people either do internal attribution or external attribution. Internal attribution, when causes are understood in terms of internal characteristics of people, and external attribution when causes are understood in terms of contextual and situational features. The main perspective that is employed in the understanding of causal attribution is the naive scientist perspective, and this has emerged from the research on attribution itself, and it views attribution process as a detailed and systematic causal search. And this is the dominant view about understanding attribution in social cognition. However, in recent time this is not the only view. There are alternative views also which try to understand how people make quick judgments about causality. So, now the question is that why is it that people make causal attributions? The answer to this question can be provided in terms of need for prediction and control. People need to predict their environment, and hence it is important for them to understand antecedent conditions of any behavior or any event. Also, causal analysis is related to various other processes other than attribution. It also becomes the basis of regulation of responses. People also develop causal theories based on their experience, and they employ these theories in different domains. As far as attribution theory is concerned, it consists of mainly three theoretical formulations. One is the Heeder's theory of naive psychology, the other one is Jones and Davis's correspondent inference theory, and the third one is Kelly's covariation model and causal schemas. There are other areas of psychology also from where some principles have been picked up and extended to understanding of causality. These areas are emotions, self-perception as well as personality. Psychologists have also tried to understand attribution in specific domain areas. Psychologists have tried to outline the different dimensions that people use to understand causality in domains such as achievement domain, that is understanding causality regarding achievement related behavior such as success and failure, depression, helping behavior as well as close relationships.